number 10-1-0262, State of Hawaii versus Brian Murphy, for a motion to modify special terms and conditions of probation.
Good morning, Your Honor. Tracy Jones, Deputy Prosecuting Attorney appearing on behalf of the state.
Good morning, Your Honor. Christopher Dunn on behalf of Mr. Murphy, who's present and in custody.
Good morning. Good morning, Mr. Murphy.
Your Honor, can we approach briefly off the record?
Any objection? All right, you may do so. All right. Well, before we begin, one of the matters discussed at the bench was related to the court's rules relative to the recording or use of electronic devices in the courtroom. I just want to make sure everyone understands that there are certain rules concerning the recording of proceedings in court, and those are provided for by rule. For example, you saw a camera in here earlier for an earlier case. They had to file an application for coverage to comply with the court's rules in terms of their ability to record the proceedings. So please, I don't want to have any circumstance where anyone is not aware of the rules of the court. So please make sure that if there's any intent to record or in any fashion, be it audio or visual type of recording, that there be an application for coverage filed first, so that we don't have any issues on that. Second, you asked for the opportunity to respond to orally to the motion, and there's no objection to that.
Thank you, Your Honor.
All right, very good. You may proceed.
Thank you, Your Honor. Judge, you've presided over this case for several years, and you've been a witness to some of the struggles that Mr. Murphy's had with his health, both physical and mental. At least the court's been aware of that. The issues that I raise in today's motion were foretold in the pre-sentence investigation, which outlined Mr. Murphy's various health issues. And at the time of sentencing, I raised concerns about his ability to get adequate care and appropriate medication while confined. And it appears to me, or at least I've represented so in the motion, that my concerns have come to fruition. And Mr. Murphy's mental and physical health is deteriorating. I won't belabor the point. I've specified exactly in the motion what Mr. Murphy is going through. I've outlined the various medications that have been employed to try to assist him, and how the medications themselves are having deleterious effects on various aspects of his life. Exhibit C, a supplemental exhibit that I filed, drafted by Joseph Lenz, a PhD.
I have reviewed that.
Yeah, corroborates some of the assertions that I'm making. So for those reasons, Judge, and I know Mr. Murphy would also like to speak to the court regarding some of the negative health complications that have happened since he has been confined. And I have two essential requests. Number one relates essentially to his more immediate health issues and his being confined at MCCC for the balance of that year. I'm asking that the court modify his probation so that the 1-year jail term can be served under house arrest via electronic monitoring. The company that I've proposed to use is 24-hour bail bonds, and there is a representative of 24-hour bail bonds present in the courtroom today. It's Derek Kina. To the extent that the court would like to inquire of him logistically exactly how it would work, how they would receive a report of any violation of the electronic monitoring immediately, and he'd be prepared to do if ordered by the court to forward that information to the court or to probation or to the prosecutor's office or any of the above. Mr. Murphy would, of course, bear the cost of that electronic monitoring, and any request regarding the use of medical marijuana while on probation would not apply to any period of house arrest. The second request for modification was something that I don't perceive to be unclear based on the record of the case and the way that the plea negotiations happened, the way that the change of plea happened, and the way that sentencing happened. However, despite my assertion to probation that it was everybody's intent that Mr. Murphy be allowed to use medical marijuana consistent with our medical marijuana statute while on probation, Mr. Murphy's probation officer believes otherwise and has indicated that she will pursue or at least submit affidavits to the prosecutors for consideration for revocation of probation if Mr. Murphy were to test positive for marijuana use while on probation. So to avoid that, I am asking that the court amend the special terms and conditions of probation to affirmatively state that the defendant may use medical marijuana while on probation, consistent with the requirements of HRS 329-121-128. I know Mr. Murphy has some things he would like to speak to the court regarding his medical.
Certainly, yes. Mr. Murphy, this is something you'd like to say to the court. You may do so at this time.
I mean, I've kept track of the medications I've gotten from MCCC from just November 6th through November 13th, and it works out to 49,520 milligrams of medication, of which 4,350 really affect my liver. I have multiple medical issues that sort of complicate the situation at MCCC and their limitation on what they can prescribe or can't prescribe. And these are all just legal drugs, not anything else. I have an issue called complex migraine seizures, which is a form of epilepsy. For that, in the 8-day period of the 6th through the 13th, on 3 days I had to just use 75 milligrams of a product called Imidrex. Now, through the Veterans Administration, I would also be allotted to be able to use the Imidrex, which is in the injectable form, versus in the MCCC. It's a very complicated situation just to get the sublingual. Another medical issue that I deal with is a part of why I have a 60% disability through the Veterans Administration deals with a fissure fracture of the left patella, which is my shattered kneecap that gives out quite often. I also have a issue that I don't know if it appeared in these documents or not, but Dr. Rogers had suggested that I either get some injections or if it continues to worsen my back issue, to get surgery. The liver damage. The 4,350 milligrams of the different drugs a day affect my liver directly because of the hepatitis C. And then the list of drugs that they're giving me they give me a product called gabapentin, which is technically a psych drug, and I get 1,800 milligrams of that a day to try and deal with the pain issue. At MCCC, they do not give any pain relief as part of their program. I also get 2,400 milligrams of a product called ibuprofen per day. Again, it really severely affects my liver. What I was asking the court through Mr. Dunn was, through the house arrest, that I would abide by the fact that I would only use the Veterans Administration for my medication, which would decrease it from over 4,000 milligrams of negative to my liver type of drugs to under 400 milligrams per day on a bad day. I do understand that the liability factor would increase to where if I do violate this, I could actually be sentenced to 10 years in jail. And the problem that I'm actually running into is the limitations of the drug availability and the doctor part, and the, be able to see someone for my PTSD and bipolar aspects is non-existent, because it turns out it's a county time jail versus a state time jail, is what has been explained to me at the medical facility here at MCCC. And I just would actually ask the court in the crime that I pleaded no contest for, we never proffered here at this organization. We were strong-armed by people and no one would help us in that area. Okay, wait, I'm sorry, I get carried away, but I just wanted Your Honor to know that I am concerned about my physical health and do understand the liability, and I would like the opportunity to show this court that I can abide by the rules, and technically I'm asking for mercy to have the ability to have the Veterans Administration be the one provider for my medications and do this.
Judge, the only thing I would add is, as the court knows, this case was pending in one form or another for 7+ years. That entire time, Mr. Murphy was supervised by Maui Intake Service Center, and he never missed court, never stepped out of Maui Intake Service Center. I mean, he can handle the responsibility that is implicated in the motion.
Thank you. Thank you, Mr. Murphy.
Thank you, sir.
Ms. Jones.
Your Honor, it's the state's position that Mr. Murphy is a perpetrator of a serious crime. He's been convicted and sentenced by this court, and that the court heard lengthy argument regarding the sentencing position from the parties. And this court imposed the 1-year jail term in its experience, knowing that this person is a perpetrator of serious crime. And although he is facing some medical challenges, what he doesn't present to the court is a medical doctor's perspective of his situation. And he is under the care of the Director of the Department of Public Safety, who is in charge of providing his medical care, which it sounds like from what's in the motion and what the information Mr. Murphy's given to the court, he has been appropriately medicated per that department. And if any modification is to be made based upon a medical situation, we'd ask that the court set this for an evidentiary hearing and have Mr. Murphy present evidence from a medical doctor that he's unable to be monitored in the jail for the next, say, 10 months of his sentence. Absent that, we'd ask the court not to disturb the sentence and leave his period of incarceration as originally ordered. And in regards to the clarification of the order on modification number 2, we'll defer to the court. That seems to be an issue between the court's order and the court's probation department. Thank you.
All right. Before the court today is defendant's motion to modify special terms and conditions of probation as outlined by defense counsel Mr. Dunn. The two requests are, one, to modify the condition relative to the 1-year jail sentence to provide for house arrest to be monitored for 24-hour bail bonds at Mr. Murphy's expense, and the other is to clarify the order relative to the prohibition related to the use of alcohol, unprescribed or illegal drugs. With respect to the sentence itself, Mr. Murphy, without going through everything again, the court attempted to create a sentence that provided an appropriate remedy for the circumstances before the court, and also to create a plan of probation that would create a successful model for you. And I am, and as I am in all cases, deeply committed to trying to create a successful model. There were a number of issues that I discussed that went back to even your childhood days. I don't think I need to go over that again. It's in your pre-sentence report, and I don't think we need to dwell on those issues. But there were a number of issues that were of concern to the court. Additionally, the court did commend you for your service to the nation in terms of your prior military service. And so, I don't know if you remember this, but one of the things that I mentioned at the time I sentenced you, and maybe just because at the time that I sentenced you, you had a lot on your mind, one of the things I indicated was that the court does attempt to work with veterans. Anytime a veteran's case comes to my courtroom, I run essentially an informal veterans court program. We don't have any funding for it, but in my view, that's something extremely important. What may have been missed at the time, because perhaps you were considering other aspects of the sentence, was the court's statement to you that you should come up with a plan in terms of addressing some of the issues that we discussed that, again, I'm not going to go over today, but you should come up with a plan for the court so that we can discuss something that would be viable in terms of your probation. You're right. If you don't do things right on probation, the fall can be a hard one, and it can involve 10 years of incarceration. When I put people on probation, I do not want them to fail. In my view, someone going to prison is a failure. Now, that's not the model we want to create. So I'm deeply committed to anyone's success as it relates to when they're on probation or in drug court or wherever the case might be. And that's no different in your circumstance.
Well, Your Honor, that's just to reiterate what you're saying. That was what, after reflection on everything, was to decide that I would only use the Veterans Administration as my primary caregiver. What they say and allow medically is what I would abide by, is what actually, from what you said, is why I was going that direction. So.
All right, well, thank you. Well, I can appreciate the arguments or the statement that you've made today to the court and the arguments that have been presented on your behalf. I don't think we've reached that point where you've come up with any kind of plan, other than simply house arrest, which in the court's view, respectfully, doesn't address the kind of issues that I thought needed to be addressed. So.
Then I'm actually a little confused too.
Sure, I'd be happy to elaborate a little bit on that.
Okay. And I thought that's what I was doing by basically surrendering all my medical care and only through the Veterans Administration is what basically I thought we were presenting here today, and I thought that's what you were influencing or commenting on prior. So that's
sure.
why I was going that direction.
Well, and I appreciate you letting me know that, because then that helps you understand where we're at this stage right now. And so I'll elaborate a little bit on that. But at any rate, I'm not of the view that we've reached that. And my entire focus at this point is on you being successful in probation. I know you were starting to touch on other issues, but I want you to understand, and that's no problem. That's not a problem at all. I want you to understand where I'm coming from, and so that you can understand what I think would be a successful model for you in terms of probation, because that's the goal here. Yes. All right, and so that's my focus, is on you and your successful completion of your probation period, as well as the rest of your life. Anyone in my court will know that I always view life issues as much more important than the legal issues, even though the legal issues here are extremely serious, and they are in any case that comes before this court. And as a result, when I say the life issues are more important, you can appreciate the level of importance I put on the life issues if I consider the criminal issues extremely important. I think you need to work on a plan that I think your attorney, who's extremely competent counsel and does work with individuals who need to come up with rehabilitation plans, he can assist you with. But basically, it would be a plan with some details concerning the various issues that I raised. And again, I don't want to belabor that. That was stuff that was contained in the pre-sentence report. It goes back to your childhood, and I don't think we need to go just out of respect for you. I don't think we need to go through that again. Although I'd be happy to meet with the prosecutor and your attorney and outline some of those issues. But they're personal to you, and they're not part of a public record.
I'm just confused, and maybe you can clarify something for me here. As in, I don't know, maybe if the court wasn't aware, but actually I had gone back to college a year and a half before actually I got sentenced. I kept the 3.50 average. I took the aspect of going for a substance abuse counselor in human services so I could actually educate myself and others about what's good and bad. So I have actually taken those steps I thought, in going in the direction as in getting it together in the employment or school aspect. And the issue that I'm just dealing with currently is that my health is deteriorating rather quickly, and that's the scary part of the situation for me. And I understand and am willing to abide by everything the court suggests.
Sure.
And I thought I was on the right track of what things have you suggested, of going back to school and picking a career mode that would actually educate me on past issues that I had and be able to go forward. So,
well, that's good. And I think what we need to do is get some of this down as some form of a comprehensive plan for yourself for probation. In essence, that's one of the conditions of probation anyway, and we always ask individuals to work with their probation officer to develop a service plan to help you successfully complete the period of probation. So it's actually already in your sentence, but that's something I think you need to develop and take ownership of. In other words, your plan. In writing, so that you have something that you can look at that sets forth what your plans are for the future. And I think that's the kind of thing that I would want to look at, and I would want you to be working with Veterans Administration and or Vet Center as well, because I think they can provide valuable assistance, and I know there are individuals in the community that would be happy to reach out to you. Indeed, my sense is that some of those individuals have already done so. Yeah. They were there in support of you at the time of your sentencing. I'm not clear on you had veterans there in support of you, but I wasn't clear how that might have connected to the Vet Center and the Veterans Administration. But I do know they were present there, and I do commend them for being there to provide you with support. But at any rate, in terms of a plan, house arrest, that isn't necessarily what. Well, rather than comment on that, I think maybe the simplest thing for me to say is that it would be valuable for you to come up with a comprehensive plan. Yeah, I think you can do that in relatively short order. Write that out. Work with it. Work with Mr. Dunn on it, and you can present it to the court, and I'll give it very serious consideration. Any veterans case that's before the court, in my view, given the sacrifices that veterans have made, is entitled to special consideration. You're no different than any other veterans case that I would handle. I have another gentleman who's on a review hearing today who's, I'm not going to comment on his case, obviously, but he's here, he's got a review hearing himself, and we work together to try to create a successful model. I want you to do the same thing. He's got a number of things that he's doing, and like other veterans, I want you to do the same thing. We don't have a funded veterans program here, so it's informal and unfunded, but I don't see any reason why it can't work. I think Mr. Dunn would know what kind of plan I'm talking about, but so why don't you talk to him about it? It needs to be something comprehensive that goes beyond just one aspect of your sentence. Okay?
Again, just a little confusion for clarification was, I do have a plan of going back to school in the summer if everything went forward today, and I was mainly looking at the opportunity of getting my health and mental stability back on target to do that. And I understand what you're saying, and I will work with Mr. Dunn to put that together, and I have been and do have, and that's what I'm saying. I guess I'm just a little confused because that's what I thought I was doing today.
Well, to the extent that I might have contributed to that, I apologize. And so what I'm going to ask you to do is sit down with Mr. Dunn, and if you could please talk to him about that. What I'm as to that aspect of the motion, I'm going to deny the motion, but I'm happy to entertain another motion as soon as you're ready with something in writing that I can review and we can discuss. And that's something you can start working on today. So as soon as you're ready with that. The one thing I would want to caution here, and I only say this to be of assistance to you, is when I say of assistance, I mean guidance in terms of requirements. Judgment was entered on December 5th, and if there's ever going to be an issue about, and maybe there wouldn't be, but if there's going to be any kind of issue relative to timing, a 90-day period would run sometime in early March, so it just needs to be aware of that. Then again, this is a motion to modify, so arguably that's not of concern, but there's no point in having yet another issue added to the case.
I perceive the timeline on Rule 35 motion to reconsider as the 90 days, but I think a motion to modify provision.
Yeah, we really actually don't need to have that discussion. I realize that both sides may have something they want to say about that, but that's not important. If that is kept in mind, that won't be a big issue anyway. Now, as to the second issue, the order, as the attorneys know, we have a specific language that deals with the issue of medical marijuana, and that's clearly set forth in the judgment when that's prohibited. Otherwise, the order provides for illegal or unprescribed use of medical marijuana. In this instance, if the representations to me are that it is prescribed, and I have no reason to believe otherwise. So I believe that the current condition in effect, which does not include that special prohibition, is clear. But apparently there's still some doubt about that. So with the permission of the parties, the court can have its staff communicate with the probation department, just pointing out the fact that the type of order which would prohibit the use of medical marijuana was not used here, and the language is simply illegal or unprescribed. And in this instance, provided it's done in the manner prescribed, consistent with the law, it's already provided for in the judgment.
I have no problem with court staff communicating that to the probation.
You have any objection?
No, Your Honor. We just ask that it go to the head of the probation department.
I'm sorry?
We ask that the information go to the head of the probation
Oh,
department.
yeah. I'd be happy to do that. Yeah,
Thank
that's
you.
not a problem. Actually,
Thank you.
I think as the parties are already aware, I mean, this discussion has occurred
Yes.
quite some time ago.
Yes.
Yeah, and I thought the language of the orders took care of that. I think, and so maybe there's just a little bit of confusion there. I certainly appreciate the good work done by the probation department, and don't mean to suggest that anyone there has done anything wrong, but I guess they're just trying to do the best job they can. So we'll get that clarified, and we'll speak to the head of the division.
And specifically in this case, the probation officer is Moreno.
Yeah, I don't have any problem with that. And in doing so, this will not be a reprimand of any support.
Well, no, I wasn't suggesting that.
Yeah.
That the message should be communicated to her as well.
No, and that's the way I took it. It's just for guidance purposes, because the order does allow for prescribed use of substances. So I'm going to respectfully deny the motion, and it may very well be that I'll be seeing another motion here before long, and we'll deal with that at that time. All right, and I'll ask Ms. Jones to prepare the appropriate order.
Yes, Your
Thank you very much, Mr. Murphy.